Welcome to Rebel Chaser. My name is Gail, and I have a video for you, actually two videos for you from Judge Prill in Michigan. He has got these are both videos are of the same family. They just got divorced, and I think in July it was finalized. And they're both bringing each other back to court for family issues, divorce issues, things that they aren't doing that they're supposed to be doing, or they are doing they're not supposed to be doing, that kind of thing. And the first one is the motions hearing, and then the second one is a PPO hearing where the family gets involved in this one. So you'll get to see both one after the other in this one video that I did. So I'll just play the clip and let you guys watch.
SC file number 237575 PM. Number of motions here, including motions regarding parenting time, reimbursement for expenses, summer break, show cause, and request to speak to a child in camera. Parties are present there in pro se. Would you both please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God? I do.
Thank you. We hear from the front of the court first.
Your Honor, on July 18th of 2024, a judgment of divorce entered. That order granted the parties joint legal custody as well as joint physical custody of the two minor children, E and T. Parenting time was granted to Mr. Tulaski during the school year on alternate weekends from Wednesday after school, or 3 o'clock if there is no school, until Monday morning when school begins, or 10 a.m. if there is no school. The parties were granted alternate holidays pursuant to the 2022 holiday addendum, with Ms. Malzoff being parent A and Mr. Tulaski being parent B. The parties were also granted week-to-week parenting time during the summer break from school, from Sunday at 6 until Sunday at 6. And Mr. Tulaski was granted 1 additional week of parenting time every summer, with notice to be provided by May 1st of each.
Okay, thank you. There was a motion also regarding communication provisions for consent.
Correct. There are a number of communication provisions within their order, specifically that they are to use the AppClose co-parenting application, that neither party will discuss adult topics with or in the presence of the children, that both parties are prohibited from speaking in a negative or degrading manner about the other parent, his or her family and household members. Communication between the parties is to be limited to issues involving the minor children, including appointments, and the children are not to serve as go-betweens. The children, there's also a provision that the children are allowed to participate in extracurricular youth sports leagues, which can include 1 travel hockey season per year, as well as a total of 2 sports events at any given time, so long as it doesn't impact their school attendance. The provisions with regard to the extracurricular expenses does include that the parties would share the cost for extracurricular activities, which includes registration fees and equipment costs. And that is one of the issues that is set forth here today as well.
Sure. The court also notices that there's a notice of hearing scheduled for last Friday regarding the defendant's objection to expense reimbursement. Is that all part of this?
Yes, and if it was dated for last Friday, Your Honor, that would have been.
So that's fair game too.
Yes.
Okay, yep, I see that. I'm going to try to have all these. There are a lot of motions filed. That's why the court called this second to last, because we have to get through a lot of stuff here. There's also another show cause October 4 for issue of summer break parenting time.
I have Ms. Malzoff's motion regarding parenting time. I have a notice of hearing for today for defendant's objection to the expense reimbursement request. a motion in order to show cause against Ms. Mausoff filed by the friend of the court office for allegations of alcohol use during parenting time. There is a provision in the judgment that neither party shall consume or use alcohol, recreational drugs, or illegal substances 8 hours prior to or during parenting. We also have a motion in order to show cause against Ms. Mausoff filed by the friend of the court office for violation of communication provisions. The issue of summer parenting time was filed based on a complaint from Mr. Tulaski. It was not filed as contempt proceedings, it was simply noticed for hearing. And Ms. Mausoff has the motion regarding a request for it.
Okay, thank you. Hopefully we'll cover that. So if I miss anything, Ms. Schultz, please let me know. We'll just try to address this one at a time. Let's begin regarding the show cause regarding alleged alcohol use. Tulaski, what is, and both parties respond.
Yes.
Mr. Tulaski, what do you allege regarding alcohol?
Well, the week before school, I was supposed to have my boys on Sunday at 6.
And please, when we get to the children's names, EMT, that's all we need to know.
Okay.
So but you're fine. I just wanted to put that out there first.
Okay.
So you're supposed to have the children Sunday evening,
Yes, sir.
just prior to school. What happened?
She did not show up at the drop-off point, and then I had texted her using the app close, and I did notice that she had left me a message early that morning, questioning the front of the court order. But at that point, I was already, it was my understanding from the court order that I did receive the boys, because school didn't start until Tuesday, that I would have at least Sunday night with the boys and Monday night, and then take them to school Tuesday morning. And then from there, I did get a few text messages from family stating that Cherish was at a great event, and she was consuming alcohol.
So do you have any firsthand knowledge of this?
Yes, but I just kind of blew it off. I really didn't.
What I mean by firsthand knowledge is you actually observed it?
No.
Okay.
No, I was told that she was drinking though.
Okay, that's hearsay. So.
Right. Yes, Your Honor.
Okay, but you're alleging there was alcohol use, and you said from family members. From whom?
My sister Diane Hatch.
Okay. And so you received this information, and just hold on to that thought for a second. According to the order, Ms. Schultz, or the judgment, of course, was it to be Father's time that Sunday evening?
The language in the order is silent as to when summer break ends. Historically, our guidelines within the front of the court are that summer parenting time starts the first Sunday after school releases, and it ends the first Sunday after school resumes. But that is not specified in the judgment.
That's a problem. And I think both parties were represented by counsel too, correct?
Correct.
All right, so that's the alleged parenting time issue. Do you have any evidence you wish to present regarding alleged alcohol use by mother?
I did present that to front of the court.
Whatever the friend of the court receives is not put in my file, the court file. That's confidential.
We did attach the complaint, the written complaint, as well as the written statement from Mr. Tulaski. There were some pictures that were provided that were filed with the court. I will note that there was an email that the friend of the court had received from a third party that was not filed with the court, because the third party is not a party to our action, and we can't consider that.
Do you wish to call any witnesses regarding this allegation of alcohol use?
My sister Diane Hatch is here.
Okay. Do you wish to call her as a witness?
Sure.
All right. Ms. Hatch, would you please step up to the witness stand?
She's going to kill me.
To the witness stand.
Oh, sorry.
Okay. Well, it's just, and let me explain, it's the rules of evidence. I cannot rely on hearsay. I have to have direct knowledge.
Yes, sir.
Would you please raise your right?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you?
Yes.
Thank you. Please be seated. Your name is Diane Hatch?
That is correct.
Okay. Go ahead, sir. You want to ask her some questions?
Diane, on that day, you did witness Cherish consuming alcohol, correct?
That is correct.
And you did notify me that she was at the great event and she was drinking.
That is correct. And from my understanding that we needed proof, and so I did take a picture and send to you.
Any other questions?
No, sir, Your Honor.
Miss, do you have questions?
I have no question.
Okay, I do. There's more than one photograph though, correct?
Well, on my, terminate, or I would like the PPO.
Well, we're not talking about that. We're
I
just-
know, so that was just one photograph that I submitted to my brother.
The court is in receipt of two of them.
There was one from Don Glasgow that was posted publicly.
Okay, is that the one where they're all pictured together?
Correct, yes, yeah.
And did you provide that photograph to anyone?
I believe another family member provided that to Don.
Okay. The one you claim to have taken would be this one?
Correct, yeah.
Hard to see.
Sir,
At the time that you took this photograph, were the children with mother?
No, they were not with the mom.
Okay. Oh, there's another photograph. Did you take this photograph?
I did not take that one.
Picture appears to be of Chief Hartzell and mother. I know it's some distance away. You see that photograph?
yes.
I know it's some distance away. Where did you get this photograph?
That might have been taken by Tim and sent to Bernie in an attempt to try to.
Okay. Any other questions by anyone?
No, sir, Your Honor.
You may sit down. Any other witnesses you wish to call regarding this issue?
Tim Hatch was also present at the great event and witnessed Cherish.
You wish to call him as a witness?
Sure, Your Honor.
Mr. Hatch, would you please step up to the witness stand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you?
Please state your name.
Timothy Hatch.
Go ahead, sir. What questions do you have?
Tim, on that day, did you also witness Cherish consuming alcohol?
Yes, I did.
Any other questions?
No, sir, Your Honor.
Miss, do you have any questions?
No.
Did you take any photographs?
Yes, I did.
The one I showed you just a moment ago, I know you would be able to see it back there. Is this the one that you may have taken?
Took that one.
Okay, this one right here.
Yes, sir, Your Honor.
Which one did you
I
say?
took that one.
Okay,
The top left.
I thought I heard Miss Hatch say she took that.
I may have sent it to her, but I am the one who took that picture.
Any questions in light of the courts by either party?
No, sir, Your Honor.
May I accept that? Any other witnesses regarding this issue? Regarding alleged alcohol consumption?
No, sir, Your Honor.
Do you wish to present any proofs?
May I address the court, Your Honor?
Absolutely.
So on August 25th at 8:22 a.m., I did message Brian via the app code. And I said that school starts the following Tuesday, so our new schedule would start where he gets the kids Wednesdays to Monday morning. I have consistently provided a safe and loving and stable environment for his children. His claims of instability are unfounded and intended to deflect from his own abusive behavior, which is well documented. The non-custodial parent exploits ambiguities or loopholes in court orders to evade compliance and shirk responsibility, demonstrating disregard for the court's directives in the best interest of the children. I have always acted in accordance with the court orders and prioritized the safety and well-being of my children above all else. He levies unfounded allegations of substance abuse against me as a tactic to impugn my character and credibility against the court. Parent time does not stop for me. I'm a parent 24/7, 7 days a week. E and T are not the only children that I have. I do attend community events, fundraisers. If the Rotary Club or Chamber put on an event, I do attend events and support. That does not make me an incompetent mother. My children are never present. I don't drive. So I don't have any substance abuse issues. And I submitted a letter from Stephen's father, who's chief of police in Metamora Township as well.
The problem is that's hearsay unless he's here to come and testify.
Okay. So, and I have the statements from people present and.
Do you wish to call them as witnesses?
They're not here.
That's a problem,
Okay.
because they have to testify regarding what they may have seen.
Okay.
So you've seen these photographs, correct?
Correct.
You've heard the testimony
Correct.
this morning. Do you agree with the testimony as to who took the photographs?
There was a lot of photographs being taken that day, so I would assume it was one of them. I was aware that they were there.
Okay, well, you can't assume anything.
Yeah.
But photographs were taken,
Yeah.
correct? And this is during your time, your custodial time with the children, correct?
Yes, they were away with family.
Right, so when you come home after the event, were the children with you?
They were staying the night with my mom
Why?
because my nephew was up the night before. My nephew stayed the night at my house for the end of the year. They don't see each other during the school year. So all the kids stayed at my house Saturday night, and then on Sunday, they were going to their grandma's.
Okay. So are you stating that the children had a safe environment
Yeah,
while you were attending this event?
yes,
But when did you get the children back?
the next day.
Do you have any questions?
Yes, Your Honor.
This has any questions of me.
Yes, sir.
Go ahead.
When I got the boys E and T back on Wednesday, Ethan had told me that
You can't say what, you can't go to what he may have said. That's hearsay.
this is based on what my son has told me, though.
So based upon what your son may have told you, what did you do?
Well, he is saying that,
Well, we can't go for what he said.
Okay.
That's the unfortunate part here. That's called hearsay, and the court cannot consider hearsay testimony. Because the other party doesn't have the opportunity to ask questions of the individual who may have said that.
okay, well, I'm just saying that her story doesn't match up with what Ethan told me.
Okay, then that's fine.
Okay,
That's fine. but please don't use the child's name.
Okay, I'm sorry.
No, no, that's okay. But and you did receive the children on Wednesday.
Yes, sir, Your Honor.
Okay, and this kind of ties into the other motion, and I believe the communications provision deals with that closely was texted, correct?
Yes, but it also deals with the negative and degrading communications. How the complaint is written. And it ties into the extracurricular activities for the children, which is not lost.
Okay. Well, let's address this one first regarding the alcohol consumption. There is contained within the judgment. Let's see, that judgment was entered on July 18th, which is not that long ago. Just a moment. Page 4 of the judgment indicates it's hereby further ordered and adjudged that neither party shall consume or use alcohol, recreational drugs, or illegal substances 8 hours prior to or during parenting time. Clearly, at the time that this matter was brought to the attention of the father, the children were with mother. And by the way, you acknowledge consuming alcohol during that time frame, correct? Okay. So clearly she was consuming alcohol. The question though is on their parenting time. Now it's really custodial time, but here, according to the testimony, and it's not been controverted in any way, the children were not with mother at the time. Children were with another individual, and the children were picked up the next day by mother, according to the testimony presented. Clearly, it appears that despite the fact that alcohol was consumed, the children were not with mother at the time, and that's the reason for having this order in place. The whole idea here is when you have your children, there's no alcohol, there's no recreational drugs, period. So to say, for instance, that, well, I'm going to spend a weekend, let's say I'm just going to spend a weekend with family and friends away, and the children are with someone else, even though it's my parenting time, common sense would indicate that you have the right to consume those substances, alcohol or whatever, so long as the children aren't around. And the whole idea of that is protection of the children. Though I make the finding she was consuming alcohol during her time, the children were not with her and were not with her until the very next day. So regarding alcohol consumption, though I find alcohol was consumed, I don't find a violation. Now, it'd be a little different if, let's just assume the great event. At the great event, have a couple cocktails, everything is great, and then you go home and spend time with the children. That's a violation, no question about it. So I don't find a violation relative to this matter because there's no other testimony to indicate that mother had the children either 8 hours prior to or during the time children were, that the alcohol was consumed, the children were with her. So I'm going to deny that. However, let's go to the next issue, and that is communications. What's the issue regarding communications, sir?
I didn't have any.
Wasn't there some negative and
Oh,
judicial? Can you help me out on that, please?
So the complaint that was filed is related to various posts that have been made on social media, which includes posts about Mr. Pulaski and his family members. There were a number of various attachments to that complaint that appear to be screenshots from social media, primarily from Facebook.
And who is the alleged party at issue here?
It is alleged that Ms. Mausoff was making this post in violation of.
Okay. And did you notice this up or did Mr. Pulaski?
The friend of the court noticed it for show cause based on the red complaint that Mr. Pulaski submitted.
Okay, can you direct me to the section? There are a lot of screenshots and messages here.
Right. The complaint specifically just outlines that the parties are prohibited from speaking negatively or in a degrading manner about the other party, his or her family and household members, which does include verbal comments, text messages, social media posts.
Okay, this is dated September 17th, correct?
The complaint was received by the friend of the court office on September 17th. It indicated that on Friday, September 13th, it was brought to Mr. Pulaski's attention that Ms. Mausoff was posting about him and his family members in a negative manner. And then he was asking for enforcement of the communication provision.
Okay. And is this, for instance, there's a photograph of dare you to send this song to your ex?
Yes.
Okay. Okay, so you did notify the friend of the court of this, sir?
Yes, sir, Your Honor.
Okay, now you know what I'm talking about?
Yes, sir.
Okay, what's the issue, sir?
Well, it does state in our divorce papers that we can't speak badly about one another or the opposite family.
And you believe that's occurring here in this matter?
Yes, sir, Your Honor.
Okay, response, please.
I agree with that, and all of those posts that you're looking at, Your Honor, are posts that have been posted by his family throughout the course of the last year about me. So everything you're looking at is about me, posted by them.
That's not true, Your Honor.
Well, the photograph of this dare you to send this song to your ex appears to have at the very top of it Donna Tulaski Perutsky. Who's that?
That would be my sister.
Your sister? And then something about smear campaign. One of the clearest indicators you've got a mentally unstable person on your hands is smear campaigning.
I shared that, Your Honor.
You shared that.
Yes,
Okay.
didn't put a name, didn't, just with everything that they posted about me.
Okay. How does that help the situation?
It doesn't, but it has stopped since then. The online harassment and disparaging remarks and heinous accusations about me committing crimes.
Well, I do see one here regarding Sandpoint information needed. In the last 4 days since my brother's divorce, my family has repeatedly been the victims of dangerous vandalism.
Yes, Your Honor, I was being accused of slashing our tires. And it was being posted on multiple community pages.
Your name was never mentioned.
Pardon me?
Cherish's name was never mentioned in those posts.
Well, your name wasn't mentioned in the other post either. I mean, let's go back to dare you to send this song to your ex. Smear campaign didn't mention your name, but I'm just going to cut to the chase on this. For lack of a better phrase, knock it off. There's no reason for this. The issue I have with this is how does it benefit the children? It doesn't. It doesn't benefit them in any way, shape, or form. And I don't care if it's a party doing it. I have no authority over family members. I have authority over both parties in the courtroom. But at the end of the day, this is uncalled for, it's not needed, and the parties need to, you were divorced in July, and I told you after the divorce, despite the differences you may have with each other, you need to put those aside and focus and have a united front with your children. And the reason for that is because they are going to pick up on this stuff. They're bright kids. I mean, one is 15, correct?
My stepson, Your Honor.
Stepson, okay. How old are the children between the two of you?
5 and 10.
5 and 10. Well, let me tell you, 5-year-olds are bright young people, and 10-year-olds really know what's going on, especially when it comes to social media. And sure, you could say, well, they probably don't see it or that, but believe me, they do. And I don't see any post from father here. I see from family members. But to the family members who may be doing this as well, ask yourselves, why? How is this going to benefit the children? I find mother in contempt for violating the court, the order of the court relative to negative communications, relative to the texting. I understand father's name was not mentioned, but ask yourselves, where and how does that help our children? It doesn't. I do find you in contempt for that. We'll address the sanction in just a moment. Ms. Schultz, communications as well. Anything else with communications you need to address?
I think that covered the communication. We have I believe it's just the parenting time and the extracurricular activities and the acceptance associated with that. Your Honor.
Okay. And the parenting time, you're talking about the summer parenting time?
We have two issues. We have the week of summer parenting time based on Mr. Pulaski's complaint. And then we have Ms. Mausov's motion regarding extracurricular activities with children during parenting.
Okay. All right. Well, let's address first the summer parenting time issue. Father, you're claiming you did not receive the week that you were supposed to receive, in your opinion, right?
Yes, sir, Your Honor.
Okay. There is a friend of the court policy relative to that. Ms. Schultz, what is the policy?
Well, actually, Your Honor, I would rely on the written order itself.
Right. I mean, the written order is what the court goes on.
Because our former policies did include the additional summer time. That's not necessarily incorporated into the current policy. But the order does say May 1st of each year, he gets 1 extra week of summer parenting time with that notice provided by May 1st. Mr. Pulaski did reach out to the friend of the court office, and he had attempted to request dates from Ms. Mausov, reached out to us to say that she wasn't willing to grant a week that he was requesting. Our initial response was that there wasn't notice provided under the order and we were unable to do enforcement, but we did defer and instruct that if you wish to bring that issue to the court, you could certainly do so.
Any comment relative to that, sir?
Well, Your Honor, the order was placed in July, so obviously I couldn't give her prior notice in May.
Right. But your attorney could have addressed that, and that could have been placed in the judgment. See, that's the problem. I have to work off the judgment. And if the judgment says this is how you do it, that's how you do it. I can't waver from that, because then I'm going contrary to what the parties agreed to. And had the divorce entered prior to May 1, sure, you would have been entitled to it. But since it entered in July and the judgment is silent regarding that provision, I can't enforce something that's not in the judgment. It's no disrespect. It's just I have to follow what you've agreed to.
I understand.
So obviously next year that'll change, and you know when to get that information to the friend of the court and to the other party. So I have to deny that issue, but also this, are you claiming denied parenting time between the Sunday of the great event to Wednesday?
Yes, sir, Your Honor. And friend of the court didn't, they have the audio from our conversations between Cherish and I about exchanging the kids on that day. And the audio should state that Cherish did say that she had the kids. So that contradicts what she is saying.
You didn't admit that earlier, though. And number two, an oral agreement's not worth the paper it's written on. So if there's some oral agreement or something out there,
Well, there is text messages and there is audio evidence that is on Appleclose.
well, again, the judgment, I have to go based upon the judgment again. And the judgment does not indicate, because I did ask Ms. Schultz as well, because I didn't see it, regarding you would have the Sunday to the, and through the Wednesday. So I can't grant you that time either. I
Even
have
though
to-
she was willing to,
Willing, it's just like coulda, woulda, shoulda. Even if she's willing to, this is a different situation. It has to be in the order or the judgment. But I'd like to address it now, though. Ms. Schultz, we should have an agreement, an addendum to the judgment to indicate that when the summer parenting time ends.
Yes, please.
And what do you recommend?
Generally, our policy would be the Sunday before school resumes, but I'll defer to the parties.
Okay. You want the Sunday before school?
yes, sir.
Your
Can I just clarify? So would the new parenting time start taking place Sunday at 6 p.m., the week school begins, correct?
Yes, correct.
So then,
Generally, yes.
okay,
That,
so then-
that's not what Mr. Pulaski is requesting. He's
Right.
requesting that the school year schedule start as of the first day of school. That's what I.
Is that what you want?
Yes,
First
sir,
day?
Your Honor.
Oh, that's different. Do you have any problem with that?
I think it's in the children's best interest to have a consistent schedule during the school year with it, the parenting time ending Sunday at 6 p.m. And the school year, it started on Tuesday. So Monday was a school night, and just to keep consistency for them, I think it's best that the school year schedule start the Sunday before school resumes.
And you want to start the day school?
Yes, sir, Your Honor. She only has them 2 more days a week. So I don't know how it would interfere with the boys' schedule. It's not like I don't take them to school also.
Okay. Well, there's no agreement on the matter, and frankly speaking, we need to clear up this order so we don't have these issues again. I'm granting the relief to Mr. Pulaski. Extracurriculars. Go ahead, Bob.
So Ethan has been playing hockey, he's been playing hockey since he's been 5 years old. Brian has been very open about his dislike for it, does not support it, wants nothing to do with it, has never been involved with it. And it's almost as if he is being used as a pawn for a power struggle. That he has never missed a game or a tournament the whole duration of our marriage, but is starting now. I understand that he said he wanted to do something else that Saturday morning.
You thought, right?
Correct. Whether that's true or not, there was no reason he couldn't attend his games on Friday or Sunday. And those were not the only games he's missed. He missed multiple games last season as well.
But the games that were missed recently, one of them included a school day, correct?
Correct,
Okay. And they were both on Dad's time, correct?
correct.
Anything else on this issue?
Ethan, he has a lot of emotional distress. He expresses this to his counselor. He talks about it at school. I have him working with a success coach as well. He has emotional breakdowns when he comes home from his father's. After that particular weekend on September 16th, when I got E back, he made a comment about
I
he's
can't
tired.
hear.
Okay,
Nope.
he was just visually upset. And I do have him write letters or write down what he wants to talk to his counselor about. And that is something that means a lot to him. And I can't it's inconvenient to me too, but I will do it for them. I've always been active in my children's extracurricular activities. I've not missed anything. I've paid for them. I've participated. I've helped coach. And now it's just something that's hurting them. It's being used to hurt them because I think he's under the understanding it's hurting me, but it's hurting the children when they're held back from these things.
I'll ask you to respond, sir.
Your Honor, I've been taking Ethan. He's not missed a practice when I've had him. And chairs can't say the same thing. Although his practices on Tuesday, when she has him, interferes with soccer practice. He's not made it to one of the soccer practices. And if you were to ask Ethan, it's very difficult, Your Honor.
I know.
If you were to ask to state his favorite sport, it would be soccer.
Can't go to what.
Okay. All right.
But I did read your position. I did read Mom's position as well.
Okay. So he has been. Now, when we were married, I didn't have an issue with Ethan playing any sports. That's his release. I've gotten him into sports. We play sports at home.
Well, let's talk about now.
And that's what she's
You
saying
would agree
that.
the child did not go to the hockey game, right?
Right.
Okay. And you were the one that it was on your time.
Yes, sir.
Okay. And why did he not go to hockey?
Well, on Friday, he went to school instead.
Okay.
And
Did
from
he do
school,
something different other than the hockey?
I'm sorry,
Did he do something different other than the hockey?
on Friday,
Yes, or the whole weekend?
the whole weekend, we did the youth hunt.
Okay.
He did play soccer on Saturday morning. We went to the woods first thing in the morning. And then we left early so he can make it to a soccer game.
Okay. And that was on your time again?
Yes, sir, Your Honor.
Now, without telling me what the child would say to you, does the child have an interest primarily in hockey or in other sports, or is hockey his number one thing?
No, I don't believe hockey is his number one. I believe soccer is his number one, football is number two, and hockey is number three.
Okay. Wow. Anything else?
I disagree, because he opted to not even play football this year.
Okay.
So I think Ethan, as most children, do tell parents what they want to hear. Because
Don't disagree with that.
they don't want to upset anyone, they don't want anyone mad at them. But I am not the only one he confides in. I mean, I see the ugly side of him, like emotional just distress, and he will open up to his counselor as well as individuals I have working with them at the school. And it means more to him than what he's getting credit for.
All right, the court will make a decision on this issue as well, because, and Mom is asking for an in-camera hearing for the child to speak with the court on this issue. Is that correct?
He wants to talk to himself.
Yes.
Mhm.
Very well. There is a rule that this court follows, and I don't think it's just a rule for this county, it's a rule across the state that the courts adopt. And that is when you are exercising your parenting time or custodial time, that parent calls the shots as to what happens. And I don't mean to be cold or crass or anything like that, but let's say there's a child that's really interested in baseball, and this child, or softball, doesn't matter, whatever. They really want to play softball. But one of the parents who has his or her time either planned a trip or a youth hunt or fishing or something different. It's the parent who has the child at the time that calls the shots. So If it's on mom's time and the child wants to go to hockey, child goes to hockey. If it's on dad's time, child wants to go to hockey, but dad says, no, I want to do something else. That's the rule. That's the rule. Now, understand that rule has a little caveat to it. Here's the caveat. Though that is the rule, the parent should always think about what is in the best interest of the child. So if the child really expresses an interest in hockey, as an example, and the parent can do it, then do it. The reason behind that is because you're taking care of the child's interest, and despite the fact that it may be burdensome as all get out for the parent, you can see that the child is happy. Does that make sense?
Yes, sir, Your Honor.
But here, the child did not go to hockey. Matter of fact, he would have lost school that day on Friday. But I'm assuming this was done prior to when the parties were married. Did they admit the child to school?
No, sir, Your Honor.
Okay, well, regardless, I shouldn't even have brought the question up because we have to move forward. And despite the fact that mom states he has a sincere interest in hockey, and I'm not questioning mom. But if it's dad's time, it's dad's call. Just like it's mom's time, it's her call. For instance, if dad really thinks that the child really wants to hunt and it's mom's week for youth hunt, and mom says we're not going hunting, we're going to go play hockey, that's what happens. That's my ruling on that issue. Officials, what else? Oh, the expenses of hockey. And I believe father has the objection regarding the billing statements.
Yes, can I just clarify the prior ruling, Your Honor? The request for the in-camera interview is denied as well.
Yes.
Okay.
My understanding, Dad, that you are receiving information of the payments made for the extracurriculars from some sort of Venmo account. Is that correct?
Yes, sir, Your Honor.
Okay, tell me about that.
Well, from my understanding, Venmo, it could be anyone. It doesn't state anything on there that it's for hockey, and even so, she could do anything with that. I'm requesting just a plain bill and receipt for anything that I need to split with her. Also, Your Honor, in the court, when we did the settlement, it was my understanding that from the settlement date, all my arrearages, I accepted all the credit card debt. So anything from that forward would have been taken care of with me taking all the credit card debt and the divorce proceedings. So anything in front of that date shouldn't have been even submitted.
Okay, but you didn't bring that up in your motion.
No, sir, Your Honor.
Well, let's address the issue regarding these Venmo payments. Mom, these Venmo payments, what are they for?
For his ice time, registration fees, and it's not just hockey that he's refusing to pay for. There was other sports on that list as well. And this is a letter from the manager with a breakdown of what each Venmo payment was for, right
Okay,
here.
why don't you hand that to Father? Okay. And sir, what you just looked at and you said you have a copy of, does that correspond with the Venmo payments?
Some of it does, yes, Your Honor.
What does it?
Christmas gift to the coaches, end of the year party. And then, like I said, some of the dates are before the order was even signed, with me agreeing to pay half.
How much for the Christmas gift to the coach?
There's various
$23.
amounts on there, Your Honor. I mean, I have a whole list of Venmo payments. It shows a picture of Cherish and then a minus amount.
Do you dispute the document that was presented to you just a moment ago?
Yes, it's just a list of payments. It's not really a document, Your Honor.
List of payments made by who?
By Cherish. Do you have that list, Cherish?
This right here, what I paid.
Yes.
Did you prepare that document?
The manager of the team sent that to me, saying what it was for, what I paid.
So you didn't prepare it?
I did not prepare that, no, it was sent to me by the team manager.
Take a look at that.
I don't know who these people, or who this person is, Your Honor.
What person are you referring to?
Alyssa?
That's the coach's wife, and she's also the team manager.
Do you have any reason to dispute that?
Yes, I don't know who that person is. I've never had any contact with that person before.
Well, she's stating under oath that it's the coach's spouse, the team manager.
Yeah. But I can type this up on my computer also, Your Honor.
Phone number is on the email, if there's an issue.
Okay. I make a finding relative to that, whatever's contained on that document, that responsibility is father's. What is not, including this Christmas gift, end of the year party. How much is the end of the year party? Is that listed on there, sir?
Yeah, it's another $20, right?
Okay, so it's all, whatever's listed on there.
And there's no dates listed. It just says July. July, January, February. Is that, it can't be this year because that, it says 23, 24. So I just don't understand all these costs, Your Honor.
All right, well, Father, you have the opportunity to speak with those individuals as well, and get that information. But I make a finding that that document is acceptable regarding the payments. However, moving forward, no more Venmo. We need receipts indicating when and what for moving forward. And if they're not submitted according to that fashion, I will not allow the front of the court to enforce that.
His team that he's on now, they don't use Venmo, but I also pay for his therapy via Venmo too. That's one of the few forms of payment that they take.
You need receipts from any therapist, you need receipts from them,
Okay,
so that we have verification of it. I'm not doubting you and I'm not doubting Father, but at least if we have something that indicates what it was for, when it was tendered, then there's no question about it. That's my order.
the specific dates that I did Venmo would be on Venmo as well.
Well, I'm talking about moving forward
Okay.
from today's date forward. I'm not going to accept Venmo. And I mean, you can pay by Venmo if you wish to, but they need to give you a receipt indicating when and what it was for.
Okay.
Otherwise, it's unenforceable.
Okay.
Does that address the issue that shows?
Yes, and just to confirm, Your Honor, the front of the court office just received this list late yesterday afternoon as well. And so based on the expense reimbursement that was submitted by Ms. Mausoff on August 12th, we have permission to review the claims versus this list, and if we find any discrepancy, we can make that adjustment.
That's correct.
Thank you.
That's correct. What's the next issue? we need to address?
That may take care of it.
Anything I may have missed, Dan?
Your Honor, back to the drinking. Front of the court has at close, and it states in there that Cherish was with the kids. She's telling me that.
Sir, we've already addressed the issue. I made my ruling on it. I have no testimony, no evidence at the time the court made its decision, other than what mother testified to, that the children were not with her, and that she picked them up the next day. That's what the court has to rely on. And that's why I always ask, is there any further proofs, anything you want to present that wasn't presented at the time? So I have to follow the rules. That's all I'm doing. Ms. Schultz?
Just to clarify for the record, Your Honor, the front of the court office does not actively monitor APCO's accounts. If parties wish for us to have that information, it must be exported and sent to our office. And we do not represent the parties. We do not admit evidence or exhibits on their behalf, except for as written complaints that are submitted for enforcement.
So here, again, just my words of advice moving forward. Communication is key. And you need to be able to communicate with each other, send proper documentation, and most importantly, when it comes to the best interest of these children, the shooting back and forth at each other, family members, friends, whatever it may be. And I'm looking at both of you. I'm not looking at one, I'm looking at both. It has to stop. If it happens again and it's proven, then we're talking contempt and we're talking the possibility of sanctions, including jail time. I don't want to go there. Not at all. Look at the whiteboard. We have a clean slate. Let's start there. This is Diane Hatch, 247810PH. This is the respondent's motion to terminate personal protection order. Respondent Ms. Hatch is in the courtroom. She's a pro se. Petitioner Ms. Malzoff was in the courtroom. Both parties were sworn at the previous hearing, so you're still under oath. The burden of proof and burden of persuasion of continuing a personal protection order rests with the petitioner. By way of record in this matter, a personal protection order was entered by this court on with me. September 13, 2024. An objection was timely filed by Ms. Hatch in this matter. So, Ms. Malzoff, what is the reason that the personal protection order needs to continue?
Since October 28th of 2023, I have been getting a lot of retaliation from several individuals from that family, including Diane Hatch, because of my divorce with her brother. It started with a lot of the online posts. She posted to my coworkers, social media pages. Pardon me?
Who's she?
Diane.
Okay, Ms. Hatch.
Yes. She contacted my family.
Well, what do you allege she posted to coworkers? Your coworkers?
Sharing accusations about me slashing tires, Your Honor.
Okay, go ahead.
On February 8th, I seen Diane at an event that the Rotary Club was putting on. She was called and told not to come to
By whom?
Dawn Tlaski.
Okay.
Called her sister called Diane Hatch, told her not to come to Frank's Plaza. That's where I was meeting Dawn. And she showed up, and she was specifically told not to because I was there. She walked in, she sat at my table right across from me. I got up, I left, and a vehicle.
She sat right at your table?
Yes.
Okay. And what happened?
I got up and left.
Why do you claim that Ms. Hatch was told not to show up?
Because I was there, and there's been a lot of tension between the Tlaskis and me.
Okay.
Because there's just been a lot of trouble and a lot of problems, and
Okay, but you didn't say that. Someone else did.
I will not talk to her.
Okay, but someone else you
Correct.
claim told Ms. Hatch not to be there.
Correct. And I mean, they wrote statements, but that's probably hearsay.
It is.
Okay. So, and then that night when I left, I was driving home, a vehicle that matches Brian Slaski's followed me home. So then there's been multiple posts throughout the year.
Is there any indication that Ms. Hatch was in the vehicle?
No, I don't believe she's in the vehicle.
Okay.
Yes. And then, other than the post that she has put out in public about me all over social media,
This is the tire slashing
that,
allegation?
yes, on Port Austin page, Queso's page, she was aware that I worked at Dark Sky for a few hours on the weekends, and she showed up there a couple of times, asking for me. And she
And you were
also,
there that day?
no,
So someone else told you that
Yes,
Ms. Hatch was asking for you.
yes, and she also wrote a statement as hearsay.
So is there anything that happened at Dark Sky?
She contacted my employers accusing me of saying that she wasn't allowed to come there. But then I had to have a talk with my employer.
Is that true?
No, I did not say that.
Okay. So you had a conversation with your employer. I can't go into what the employer said.
I was being questioned about what the problem was because they had talked to her via email before asking me what was happening.
Okay.
And then, the great event, which we've heard a lot about that, I was there. I was aware she was taking pictures of me. There was more than one picture.
And you are aware, did you actually see it?
I seen her there and I was being told, because I had my back to her, I was being told she's taking pictures of you,
Okay.
which have been submitted for,
I did review the picture.
yes, okay. And then I left. I was uncomfortable, so we left and we walked down a block, because there's a patio outdoor area there. So me and everyone I was with like 10 people, we went and sat on the outdoor patio area. Shortly after we got there, Diane Hatch and her family showed up. They sat at a table right by ours when there was nobody else in the area. There was many tables open. She sat there and a friend that I was with had mentioned to her, like, we're aware you're taking pictures. There was a conversation being had between the
Who's
two.
the friend?
Nicole Messing.
Okay.
Said something like, if you're gonna take pictures of us, make sure we're smiling. I don't know, something, because that was at the other end of the table. Diane immediately got up, came over to me and was yelling at me about my kids and where were my kids? If I was a good mom, I'd be home with my kids. I got up from the table and I walked away. I was sitting with Mackenzie Kerr. And we went into the establishment and went into the bathroom and shut the doors.
Anything happened after that?
There were words exchanged between Diane and Nicole, and I know Dawn Twinansky
In
had
the
to
bathroom?
outside, and Dawn had to escort Diane back to her table.
Okay, but you didn't see that yourself?
I
in
went to the bathroom.
Okay.
I just want to be left alone. Okay, these individuals will show up in groups at my children's sporting events, in court, which I'm sure everyone's aware of. They're constantly trying to intimidate me. I just want to move forward with
Okay,
my kids.
but when you say they, this is,
Diane's always part of it. Diane's the only one that's approached me in public.
okay,
And has talked to employers and people that I work with.
and the people that you claim that you work with that have been contacted, it's regarding specifically the post, correct?
Correct, about me slashing tires.
Right.
Mhm.
Now, in your petition, it says you have, she has shown up to my place of employment.
Correct.
Tell me about that.
So I work at your hospital during the week, but I work at Dark Sky on the weekends, and she showed up there twice asking.
Oh, this is at Dark Sky.
Correct.
Okay. Okay, it wasn't clear. And you said emailed employers / managers. That's again Dark Sky?
Correct.
Okay. All right, anything else?
I just want an end to all of this, and I just want her to stay away from me. I have nothing else to say to her. So,
That's how you want to leave it.
yeah.
Very well. All right. I'm going to make a decision right now. I don't need to have any information. Here's what I think is going on. Very simply put. We have a very, very bitter separation and divorce regarding the petitioner and her former husband. We have a very, very difficult transition since the divorce, to the extent that family members have been getting involved on one side against the other. This personal protection order was against Ms. Hatch, and the court, after reading the allegations and saw the photographs, when I reviewed it, the petitioner met her burden of proof. No question about that. What I'm hearing now is it's not only the allegations of Ms. Hatch, but the family members of the former spouse is what I'm getting. And what I see is, frankly, and no disrespect to Ms. Hatch, but I see an aunt that obviously would be concerned about her and two boys, correct? Two nephews. But it's not your battle. It's not your battle. The battle is between mother and father. And I've tried to clear that up in the previous hearing by simply stating this: the family members, knock it off. That's it. What I'm seeing here is I'm going to do whatever I can to help my brother, and we're going to take care of this. And Ms. Hatch, that's not your responsibility. You can be concerned in all of that. But if you start taking photographs and making contact with people, that's unacceptable. But it does not rise to the level of harassment / stalking. If it were to continue, the court can consider the prior evidence and consider the new evidence in establishing a new personal protection order. But what I see here, no disrespect, are family members who are poking into things they shouldn't be poking into, my opinion. The parties need to move separately from each other. That is, Dad's family, your family, and look out with what's in the best interest of these children. And by snapping photographs or asking about, for instance, what you do with your employer and all that is not going to move the needle one bit in helping these children. As a result, petitioner has failed to establish the personal protection order needs to continue. Personal protection order is hereby dismissed. The order will be forwarded to the sheriff's office and here on the central dispatch to remove the personal protection order. But Ms. Hatch, if this is happening, walk away from it. It's not your battle. You understand?
Yes, Your Honor.
Good luck to both. That'll be all off the record.
I believe this is the first time they've been back to court since the divorce. So mom's out doing stuff that she really shouldn't be doing while she is on her parenting time. Although I can understand they weren't with her, but still, if you go by the letter of the divorce decree, she's not supposed to be doing that while her parenting time is. So Judge Prill, used logic and said, this is okay, which that she did. At least the way it was told in court. Now the father or the ex-husband seemed to make an innuendo that the kids say it's something different. So who knows what the real truth is, but if the scenario is exactly the way they said it was, then, logically that's okay. Although, by the letter of the divorce decree, it is not. So, Judge Prill is taking a very measured approach to this. And, family should not be harassing the other parent. Just because you're upset that your brother is now divorced, it sounds like they weren't a very happy family together. So it sounds like, maybe they're better off apart. The family should not be getting involved. And I like the way Judge Pearl put it. I like the way he pretty much said to the family, this is not okay. This is not what you should be doing. So I got to hand it to him for that. I have a feeling they'll be back. So I'll keep an eye on it and I will update you when I can. Thank you so much for watching, and I'll see you next time.